Okay, good morning everyone and welcome to the Hudson Institute. My name is Urška Petrovčić. I'm a senior fellow at the Hudson Institute and I will be your host today during this panel discussion on injunctions for standard essential patents. Standard essential patents are patents that are essential to practice an industry standard, such as the 2G, the 3G, the 4G, and the 5G standard. These standards have revolutionized the way in which we use our phones and other devices and are set to bring even more important changes to our life with the coming Internet of Things. Smart home appliances, connected cars, smart factories, and smart power grids are only some of the products enabled by the new generation of cellular standards. Of course, innovation does not come for free, but requires significant investment in research and development. Consequently, it should come as no surprise that most of the technologies included in the new generation of cellular standards are protected by patent rights. Therefore, companies that wish to sell products that practice these industry standards need to obtain a license to the relevant standard essential patents. Everyone, of course, agreed that a holder of a standard essential patent, a so-called SEP holder, is entitled to enforce its patents against an infringer, that is, against a company that uses the patents but refuses to enter into a license. However, there is less agreement with respect to the remedies that an SEP holder might seek against an infringer. Some commentators have argued that because an SEP holder typically commits to offer a license to its standard essential patents on fair, reasonable, and non-discriminatory terms, the so-called FRAND terms, shall not be entitled to obtain an injunction against an infringer. In the view of those commentators, the only remedy that an SEP holder should be able to obtain is monetary compensation. Other commentators have opposed this suggestion, and they have said that there are certainly circumstances in which an SEP holder should be able to obtain an injunction, such as cases where an infringer delays the negotiation process and refuses to pay a royalty unless forced to do so by a court. So these divergent views are not present only in the academic discussion, but have practical relevance. Different jurisdictions have adopted different approaches towards injunctions for standard essential patents. And in that respect, the European Union and Germany in particular are important jurisdictions. In the last months, there have been important developments in Germany that have clarified the circumstances in which an SEP holder might be able to obtain an injunction against an infringer. And we have organized this panel discussion today to discuss these developments, understand what is the approach adopted in Germany and in the European Union more broadly, and understand how they differ from the approaches adopted in other jurisdictions. So we have a distinguished panel of speakers with us today. We have here Christoph Ahn, Chair of Corporate and IP Law at Technical University of Munich and member of the Managing Board of the Munich Intellectual Property Law Center. He's also an adjunct professor at GW in Washington, DC, and a distinguished guest professor at Keio University in Tokyo. Professor Ahn previously served as a judge on the Mannheim Regional Court. We have here also Claudia Tapia, Director of IPR Policy and Legal Academic Research at Ericsson. She's President of 4IP Council and Vice Chair of the IP Policy Group in Tech UK. Prior to joining Ericsson, Claudia was Director of IP Policy and the Department of Patent and Standard Strategy at BlackBerry. And finally, we have here also Adam Mossoff, Professor of Law at George Mason University, Chairman of the Forum for Intellectual Property, and Senior Fellow at the Hudson Institute. Thank you all for being here.
Thank you.
So let me start with the first question. A couple of months ago, in May 2020, the German Federal Court of Justice issued a decision on injunctions for standard essential patents in a dispute between Haier and Sisvel. And this is the first occasion in which the Court of Justice opine on issues related to standard essential patents, so it's a decision that has great relevance. Christoph, could you tell us more about this case?
Yes, pleasure. It's a very interesting case because it's the first decision that the German Federal Court of Justice, which also is the country's highest court in patent cases, both validity and infringement, rendered in a verdict on FRAND obligations, basically. In other words, on the obligations that an SEP holder, a standard essential patent holder, must meet in order to be able to obtain injunctive relief before a German patent court. Now, as you had said, there's always been a discussion whether injunctions should be available to SEP holders, and the answer that the German Federal Court of Justice gave is a clear yes. Injunctive relief in Germany, injunctive relief is available to SEP holders. But it comes with certain conditions. Injunctive relief only is available to SEP holders if their conduct cannot be qualified as abusive. In other words, if they are not abusing their market power. Because obviously, when you hold a standard essential patent, you have market power because you basically can control whether, or you do control whether the user of a standard, a potential user of a standard can actually use the standard. I mean, in terms of telephones, that's pretty clear. If your telephone, if you want to be a participant in the mobile telephone market, your telephone must be able to handle 4G as a standard, for example, or 5G in the future. And what the court said was that, for example, an SEP holder must, first of all, notify the user, the alleged infringer of a patent, of a standard essential patent, that that user is infringing upon one of the SEP holder's standard essential patents. So he must make them aware of patent infringement. Secondly, the SEP holder may be under an obligation to help the infringer, who will say that he is willing to take a FRAND, or in American terminology, a RAND license. What the difference between fair and reasonable is, nobody really knows. So it's probably like reasonable on the one hand and non-discriminatory on the other. So the defendant usually will say that he's willing to take a RAND-FRAND license, but he may not be able to formulate the conditions because he may not have enough of a feeling of what would be adequate FRAND conditions. And in these cases, the SEP holder must help the licensee to make a RAND-compliant offer. And that is quite an obligation, but it's basically a price that the SEP holder must pay for the availability of injunctive relief before German courts.
Okay, that's very helpful. And what were the most important holdings that the Federal Court of Justice made with respect to the infringer? Does the infringer have to comply with any obligations?
Of course, the infringer, first of all, I mean, once he's become aware of an infringement, he must make a RAND compliant offer. It's not sufficient to say, yes, I'm willing to take a license, but he must make an offer. Only in cases in which he's unable to, which later on in court proceedings he would have to plead and prove, only in these cases does the obligation exist that I just laid out for the SEP holder. The infringer also can be obliged to accept a portfolio license offer by the SEP holder. So the infringer cannot say, should I really infringe upon this SEP, the standard essential patents, then I am willing to take a license. But if the SEP holder says, this is the portfolio that you will need in a certain territory in order to operate under the 4G standard, for example, then the infringer the later licensee cannot refuse that just by saying, well, we don't know about the other patents that you have. I'm only going to take a license for this one allegedly, the patent that I'm allegedly infringing upon, but rather he has to then take a portfolio license. This is something that the court explicitly said in its verdict, Sisvel versus Haier.
Yeah, we'll get to this later. But Claudia, let me ask you, Ericsson was not part of the litigation, but as a holder of a very extensive portfolio of standard essential patents, was certainly interested in the verdict. What do you think is the impact of this decision for companies like Ericsson?
Well, first of all, I would like to thank you for inviting me to share with you my personal views on this very interesting topic, which do not necessarily need to reflect the company's position. But coming back to your question, I think the court made some clarifications that are very useful for a business. You know, most of the cases, companies negotiate in good faith, and that leads to front licensing agreements. But for a while, we've been experiencing companies that they argue that they are willing, but they don't really behave like a willing licensee. What I mean is that they engage in delayed tactics, like endless asking for technical explanations of SEPs and standards. And it's like they request information and you provide it, and then they request for more and you provide it, and it goes and goes and goes. And there's a moment of time where you start having the feeling it is not that they don't understand it, it's more that they want to just delay. And eventually, if they end in court, then avoid an injunction because they are willing. And so I think it's positive that the German court clarifies that these detailed technical and legal explanations are not required. And the same goes with some other delay tactics, like when you have some companies that engage in global portfolio licensing, but when they don't get what they wish and they end in litigation, then they expect the court just to determine patent by patent front and only for that jurisdiction. So I think it's welcome that the court recognizes the global portfolio licensing, as Christoph has mentioned, and that the need for the alleged infringer to clearly and without any doubt declare its willingness to conclude an agreement on front terms and conditions.
May I add something to this, Urshka?
Sure.
Basically, the court said that the parties must act in a constructive fashion. So the kind of holdout that Claudia just described would not be constructive. If you ask for sort of details and details and details, it basically is a holdout. You don't really want to enter into a licensing agreement. You just want to keep the other side at a distance. And that's not acceptable. What the court said the parties must do is work towards a license constructively.
Yeah, and I believe the court in this specific case looked at the facts of the case and said that the infringer did not satisfy this requirement. It criticized the infringer because it replied to the SEP holder's offer after a year, and then even after it replied, it did not explicitly say that it was willing to enter into a license agreement. And in subsequent communication with the SEP holder, the infringer said that it's willing to take a license only for the patents that were found valid and infringed. And the court said that that was not enough. What do you think? Was the court right in adopting this approach?
I absolutely do, because saying that you want to take a license is not enough. You must act accordingly. And if there is a finding that oftentimes, I mean, rarely are parties saying, frankly, we don't care. We are going to use this technology and we're not going to take a license. Parties usually don't say that. They sometimes say, we're not infringing, so that's opening up another theater of operations in a sense. sometimes they're saying, yes, we want to take a license, but sort of negotiations, so they act in a super smooth way, but when you look at what they're doing, you find out they're not really willing. And this is something that the court said in this ruling. It said that Haier, by the way, comes from the German Repeal, because Haier used to be a fridge manufacturer, and Repeal is a German fridge manufacturer. Second syllabus is Haier in Chinese, of the Chinese pronunciation. And they've said that they wanted to take a license, but the court said they didn't act this way. They didn't act like a willing licensee, and therefore they lost the case.
And Adam, in very general terms, how does this development in Germany compare to the situation in the United States? Can an SCP holder obtain an injunction against an infringer that drags the negotiation process and even after a year of negotiating a license, keeps asking for additional information?
Well, I won't hold you in suspense. The answer is no. Unfortunately, in the United States, we've had a radical upheaval in remedies law for patent owners in the past 10 to 15 years, following a U.S. Supreme Court decision in 2007 called eBay versus Merck Exchange, which changed the doctrine. A lot of people don't understand that. Because the court very confusedly stated that it was applying simply an historical rule, and it was not. The historical rule was the same rule as all patent owners, as all property owners, which is that if you have a valid property right and you have repeated ongoing infringement, you receive an injunction to stop that. And that's fundamental as a backstop for driving contractual negotiations and commercial exchanges in the marketplace. This is a platform for innovative commercial development of innovation markets themselves, and of driving innovation economies, both in the United States and around the world. And this was radically changed by the U.S. Supreme Court in this eBay decision, handed down this 4-factor test where you have now prongs like the public interest has to be shown not to be undermined by the issuance of an injunction, and the balance of hardships that has to be weighed, and the hardship against the defendant. And of course, the defendants can argue, especially in the standards context, oh well, we have to use this innovation, and the public has to have access to smartphones, and they come up with all of these scary hypotheticals, and the courts really have been captured by these. And the end result is that patent owners, especially owners of standard essential patents, but it's true for all patent owners in the United States now, and not just licensing entities and individuals, but manufacturers have been unable to receive injunctions for the ongoing, continuing commercial infringement of their property rights and of their valid property rights. And this is a real problem. It's really undermining the ability of innovators and of firms that deploy patent innovation in the innovation economy generally to really enter into negotiations and establish what is the fair market value for their products, and receive remuneration both for their R&D efforts, and as well as get products into the hands of consumers at what have historically incredibly low prices, which is something driven by innovation as well. So it's a real problem, and this development in Germany is really significant because it stands in stark contrast to what you see in the United States, where the German court is saying, if you are an owner of a standard essential patent, you can and should be able to receive an injunction on certain conditions. You have that stated at the very high level of generality in the United States at times, but the reality is the exact opposite in the United States right now.
So let me ask a very general question. Why is it important that an SCP holder is able to obtain an injunction?
Should I take this one?
Sure.
Or is it for Adam?
No, for everyone.
Okay. So I think that without an injunction, you will need to go patent by patent, jurisdiction by jurisdiction for patent damages. And we have in our field very large portfolios. I mean, in our case, we have hundreds of patent families and thousands of patents. So for those jurisdictions where injunction is not effective, we have parties that literally don't want to talk to us. I mean, and we are, you know, one of the leader companies in 2G to 5G standardization. And we have probably the strongest portfolio of SEP. And still, you know, you have companies that ignore us, or they set a date for a meeting, and in the very last minute, they cancel it, and they do it again and again. And they do so, I believe, because the worst thing that can happen to them in those jurisdictions is that they end paying front. And in all this process, they have a competitive advantage versus those companies who have negotiated in good faith and that are paying front licensing terms. So I think that injunction is extremely important, and you don't need to go to the extremes. I mean, you see how in Germany the SEP holder has to notify of the infringement, provide sufficient information, and if the alleged infringer expresses a willingness to conclude a front agreement, then the patent holder has to make a front offer. So you have there a quite balanced play field.
May I add something, Rushka? May I add something? I think it's important not just to concentrate on the big applicants and the big portfolio holders. Ericsson is one, and I absolutely share what Claudia just said, but what I'm seeing at my university, for example, are small startup companies that say have 8, 12 patents, a small patent family. And if these startups want to avoid being smashed by a big company like Siemens or Ford or Pfizer or, you know, the big applicants, one of the few things that really can help them is a patent. And that can only help them if they really can exclude the big competitor from a certain technology. Not from a market, but from a technology. And that is something that is often overlooked, because who is leading in the discussion of having eBay in an eBay equivalent in Germany? It's the Association of Automobile Manufacturers, German. I mean, these guys are all sitting on huge patent portfolios. Nevertheless, they obviously want a proportionality requirement. Why? Because they have huge productions. They basically want to make sure that a small company cannot make them shut down a production, which is the horror scenario that they've been presenting in the political discussion. It's never happened, by the way, not a single time. But it shows that they're afraid of the exclusionary effect. And if we want to do something for small companies, we must not take away the exclusionary or the option to exclude others, because that and only that is giving a small company leverage against a well-financed big corporation like the ones that I mentioned before, the Siemenses, the big, the fat cats, if you want.
Yeah, I mean, and Christoph and Claudia made really excellent points about the key role of injunction as backstops of what I mentioned is contractual negotiations. Most people think of injunctions as saying stop. And yes, I mean, nominally that's the effect of it is, but an injunction that issues by a court, as I constantly teach my students, and as I'm sure Christoph does as well, and Claudia as well, is never the end of the story. It's the start of the story. It's now when the infringer, the person who's not been respecting the property rights, has to sit down and have a contractual negotiation. Well, what are you willing to pay each other? Or what are you willing to pay me to use my property, right? I mean, to make this real for people who don't, work in these complex areas, right? This is what makes it possible for you as an owner of a house or of a building to say to someone, if you want to use part of the space of my property, you have to pay me rent. You have to pay me some type of money. Otherwise, nothing could stop you from someone being a squatter and just coming in and squatting and saying, I'm just going to stay here and you can't kick me out. And eventually a court will order what a court thinks I should pay for rent after years of litigation. And you spend millions of dollars on lawyers and other fees. And meanwhile, I'm getting all the economic benefits of living here, and you get nothing. And this is particularly magnified in the context of standard essential patents, because these are infringers, because they have to use the technologies. And so they're getting the market advantage of being out there without having to pay the appropriate input cost in their production scale that other competitors are paying, because they are holding out and are not entering into a license. And as Christoph mentioned, this is really important, because this is exploited by very sophisticated large companies in the United States. We know this very well in the high tech context. And the most recent example is, Sonos recently had to sue Google. Sonos was this little small startup that innovated wireless speaker technology as a startup. And Google has been dragging out and had been exploiting and outright stealing its technology for years. And the only thing that Sonos had left to do was to sue Google, since Google was refusing to negotiate with it and to pay for its license. We call this invention theft, or policy wonks call it efficient infringement. Historically, courts just called it piracy. And this is what injunctions stop, and they stop explicit commercial decisions to steal inventions, and what they facilitate are market exchanges, which is what you want to have happen, which is what drives economic growth, drives job growth, and makes everyone better off with our smartphones and our incredible medical technologies as well.
What you just said, Adam, is the position of every German patent judge I know. There's not a single patent judge I know who is against or who is in favor of introducing the kind of proportionality, basically a kind of eBay versus Merck proportionality, let me call it, argument. There are abuse cases, yes, and these abuse cases must be and can be handled by abuse rules, applying abuse rules. Those rules do exist. And but otherwise, there must be the threat of an injunction, because that gives small companies leverage, and that's what you just said. It's not the end. It's not the end of a case. It's the beginning of a discussion and of a transaction.
Yeah.
So let me go back to the decision of the German Court of Justice. The court made several findings regarding the SEP holders' offer. And as Christoph and Claudia mentioned before, the court said that it's not abusive for an SEP holder to make a license offer for its entire portfolio rather than individual standard essential patents. And this is the approach that Justice Bears adopted in Unwired Planet, and the European Commission has also emphasized the efficiency of portfolio licensing. So why is it important that an SEP holder can license its entire portfolio rather than individual patents?
If I may?
Sure.
Yeah, so licensing agreements of standard essential patent have a period of time, let's say 5 years. And very often in the ICT field, we deal with major or large portfolios. And with that, these portfolios are also dynamic. Some patents may expire, many of the patents may be included in this portfolio. And for the implementer, once they signed a license agreement, they know that in all this period of time, they have freedom to operate. And this means that they can focus on what they are better at, so bring good products in the market. And so this is why the Commission says it's efficient also for the implementer. And you need to consider that once we have these licensing negotiations, we need months and sometimes years, even with willing licensees. Now imagine how it would be if every single time that a patent is issued, we have to start the whole negotiation field. So this freedom to operate allows for the implementer to focus in the products, and us also not to be starting every single time the licensing negotiation. So it's a win-win situation, and this is why it's the industry practice. Even those companies that in courts are asking, or even in conferences are asking for patent by patent determination, once they are in the negotiation table, they all want to have global licensing. It's clear they need it.
Maybe, Claudia, you want to explain why large parts of the overwhelming part, most of the certainly Europe's, probably the world's telecommunications industry started Avanci as a company, because as I understood it, it was the automotive industry that requested a one-stop shop, basically, because which means that they wanted portfolios so that they didn't have to go to different SEP holders. Wasn't it like that?
Well, what happened is that at that time, I mean, we usually have been for many years entering in cross-licensing agreements with other companies that also had standard essential patents. And then suddenly new business models started to jump into the market. Some of them just focusing in research, some of them just maybe from Asia, from India, that they were purely implementers, at least at the beginning. And so they started to get familiar with what front is, because even those that they didn't have experience, they could hire someone with experience. Now, front reflects the value of the standardized technology to the end use. Now, how are you gonna estimate the value if it's something really new? Here with the automotive, it has a huge value. I mean, maybe you can, there's a very interesting paper from Bowman Hayden, which is free of cost for AP Council, which is dealing with the value of this connectivity. But at the beginning, you know, we had this situation that we saw that these automotive were using the technology, they were charging quite significant amounts to the consumers who were willing to pay. But still, you know, it was the situation of how much should we pay for each of the patent holders, and also the situation that we didn't need any cross-license because there were new players that didn't have essential patents. So they ask companies like Ericsson to try to think about ways to combine several portfolios. Of course, this is tricky because of antitrust concerns. So this independent platform was created, and there has been a lot of discussion between the platform and the members until finally a large part of or very strong portfolios were included in this Avanci. The rates were published, and then we had some companies already signing agreements with Avanci. That's a little bit the background of it.
I just wanted to just quickly point out and go to a little higher level, being one of the professors here, that Avanci and portfolio licensing are exactly what you expect to see when you are securing property rights in innovations, just like you secure property rights in any other area of human activity, which is that it becomes a platform for people to engage with others and embrace specialization, embrace division of labor, and achieve economic efficiencies in the marketplace. I mean, this was Adam Smith's incredible insight in 1776 in The Wealth of Nations, and this is what the shift to securing patents as property rights, historically the shift away from monopoly privileges to property rights, achieved for innovators and innovation economies in the United States and in Germany and across the world. You know, so the evolution of patent pools and portfolio licensing and disaggregated supply chains with people entering into licensing deals in the franchise business model. This is all what you experience when you protect property rights backed by injunctions, which is what facilitates commercial exchanges, facilitates economic activity, and it facilitates the benefits to consumers and everyone around the world by getting into their hands, you know, lower priced products that are produced more efficiently. And so this is what is facilitated by decisions like what you had in Germany and is undermined by what is happening in the United States under the eBay.
So if we go back to the decision of the Federal Court of Justice, another important statement that the court made was that the non-discrimination requirement of the friend commitment does not require an SCP holder to license its standard essential patents for the same royalty to all licensees. In other words, the court said that the terms of the license agreements need not to be identical to comply with the non-discrimination requirement of the friend commitment. Was the court right?
Definitely, I would say. I mean, I think that flexibility is extremely important in negotiating SCPs. And this is a part which is inherent of FRAND. I mean, if you look at FRAND, it allows to address the specific circumstances of each individual case. And you have situations, for example, with portfolios. Each one is kind of unique. So when you have these cross-license agreements, you're not really able to bring the offer with exactly the same terms to each of the parties, and also because of the preferences of the licensees. For example, if the licensee wants to have a lump sum payment, this is less risky for the SCP holder than if the licensee prefers running royalties that you may get or may not, depending how the company develops. Also, what if the implementer wishes to transfer patents instead of paying cash? I mean, there's no rule saying that SCP holders need to be forced to get paid by cash. And all these preferences and this flexibility of FRAND allows for more licensing, because you can adapt to the preferences of the parties and reach a more balanced situation, an efficient licensing system. And it's like, you know, like when you buy a car or a house, like it's acceptable that they are different terms depending on the situation.
Thanks. So when rejecting the lower court's interpretation of the non-discrimination requirement, the Federal Court of Justice said that the Court of Appeal failed to consider that the SCP holder might have been forced by a foreign authority to license its standard essential patents at a lower royalty to some licensee. What did the court mean with this statement?
Well, I'll take this. The real concern here with respect to jurisdictions that where you do not have established stable political and legal institutions and the rule of law, and a separation between private companies and entities doing innovative work in the marketplace and the government exercising its coercive force and capabilities. And of course, the primary example of this right now in today's world is China. And you know, even private companies in China are not truly private in the sense that they are in the United States or in Western Europe, where you know there is a division. You know, where you can assume that there's a division between the government and the company. And the company, you know, entities in China are very much intermingled with the government, and understandably so, because the government is an authoritarian regime, as people have been witnessing recently in Hong Kong and in other contexts. And so and this is a real problem. Because if you're an SCP owner and you're engaged with the global economy and you are trying to do business with what is a vastly growing marketplace in China, you know, you have to negotiate with Chinese entities, and which are both state-owned. There are actually explicitly state-owned and state-run entities, as well as private entities, which are not, as I mentioned, truly private. And in both of those contexts, they can demand and receive special preferential treatment relative that other private entities wouldn't necessarily be able to achieve in a true free market negotiation. And then unfortunately, implementers like German automobile companies or smartphone manufacturers like Apple then turn around and exploit those lower rates perhaps that were achieved through non-economic means, through threats of of intimidation, of lack of respect for rule of law, and things of this sort that we come to just assume as a given in advanced commercial economies in the United States and in Europe. This is used as a leverage point then by other implementers who are trying to reduce their input costs in their production chain as a way to try to depress and lower royalty rates. And it's really remarkable that the German court took cognizance of this fact. As far as I'm aware, this is the very first time that any Western court has done this yet, either in the United States or in Europe, where they have said, we have to acknowledge and accept the fact that if you are a private company in the West negotiating, in quotes, with a Chinese state-owned company in China, that is not a negotiation as we normally understand that, and it should not, as an evidentiary basis, be treated in the same way. It's really, really important. And I was surprised and delighted actually that we finally have some formal legal acknowledgement and recognition that this needs to play a role in our discussion of these issues with respect to standard essential patents in particular.
By the way, what the German Federal Court of Justice said here is a mere application of the general rule of the general prohibition of discrimination in Germany. Discrimination does not mean that you must charge everything the same. It just means that you must treat equal cases equally and that you must treat unequal cases unequally. I think that's the general, that's basically the substance of non-discrimination or discrimination. And that's what the court said here. So you don't have to charge everybody the same. You just must not be arbitrary. There must be a good reason. You must be able to explain why in a certain setting, a certain company, I mean, I'm not just explaining in the sense of I tell you why I did this, but that there is a consistent treatment here. That's the point. And of course, the reason cannot be because Daimler is big and you are small, we are ripping you off. That is not, that is of course discriminatory. But if, for example, there are uncertainties about the validity of patents and those are priced in, these could be reasons for different basically fees, setting of fees. But that's, I think, an important point. And that's what the court did here. It's just simplistic to say non-discrimination means everybody pays the same. It's not the case.
Yeah, I believe the court even referred to Article 102 of the Treaty of the Functioning of the European Union, and we know that the European Court of Justice has in the past clarified that the prohibition of discrimination in Article 102 actually refers only to cases where this discrimination can distort competition, not just, in other words, merely showing a difference in treatment is not sufficient.
Yes, because otherwise there's freedom of contract. And freedom of contract allows you to trade contract partners differently unless it's a special situation like here, where you have to license on fair terms.
So let me ask another question. There is this discussion about the reform of the German Patent Act, in particular about the need for introducing an explicit proportionality test when granting injunctions. And Christoph, you mentioned this earlier. I understand that a draft has been recently proposed by the Ministry of Justice. What is your opinion about this proposal?
I think that the lobby groups that tried to insert a a true proportionality requirement into the German Patent Act are a little frustrated, because what the ministry at the end of the day did was implement or suggest, actually, it's not, I'm not sure whether that has taken effect yet, the change, but it is going to come, and but the change is going to be little. It's not a change in paradigm, quite to the contrary. The rule still is injunctive relief is available. So something that Adam pointed out and I understood it regrets is not like, or will not occur in Germany. We will be able to, patent holders will be able to obtain injunctive relief before German courts in the future.
And in the United States, there has been also a proposal to revise the legal standard that is applied when deciding whether to grant injunctions to patent holders. A bill has been introduced into the House of Representatives that, among other things, would repeal eBay. Could you comment on this proposal?
Oh yes, and it's from my perspective, picking up on what Christoph just mentioned, it's an excellent proposal. And so it's very important for people to recognize that it's not a radical proposal. It takes us back to the regime that existed in the United States for 200 years. So I just want to emphasize it again, because the people who benefit from eBay and the people who benefit from this have been lobbying Congress and have been arguing to courts that eBay didn't change the rules. And so there's a lot of confusion about this. It did. And this would take us back to what was the original approach, which was injunctions as a presumptive remedy, which is the same remedy that all property owners receive. And what that means is it's not automatic. It's not guaranteed. It's not a per se rule. It's a presumptive remedy, which means it can be rebutted. So as Christoph mentioned, in the European context, they have rules regarding abuse, and we don't call it that in common law systems, but we have similar types of doctrines, very similar types of doctrines about, if a patent owner engaged in laches, sitting on their rights, for instance, for a very long time to exploit a position of the infringer to maximize the harm and the damages and ultimately the harm to them from an injunction issuing, for instance. Laches, like in this case, the person's sitting on the negotiations for a year. Right? So these doctrines were applied against patent owners just as much as they were applied against defendants, and defendants could show, well, in normal circumstances, an injunction will issue, but this is a special circumstance given inequitable behavior by the patent owner. But it bears emphasizing that, engaging in negotiations for standard essential patents is not by definition, nor has it ever been thought of as a per se inequitable activity. And it's also not true that owners of standard essential patents automatically have market power. There are tons of standards that have been set by standard development organizations that have failed. There's competition among standards, and so and there's and in a certain sense too, there's a tremendous amount of market power held by, as Christoph mentioned, very large established commercial entities that implement and apply standards because they will just move ahead and do so because they have to. And so they are getting the benefit, all of the commercial benefit, all of the goodwill benefit, everything from their ongoing use, unauthorized use, ongoing infringing, which they have to do, which they claim they can do, from the use of the standard. And the standard owner, central patent owner, if they can't get an injunction to stop that, if they can't say, I can show that you were acting with a invention theft business model here, and therefore I'm going to get an injunction against you, I'm going to stop you, then they are ultimately forced into a worse situation where they have to incur all of the expenses and the costs of litigation, and on top of just what would ultimately have been given to them at the end of the day, which is a FRAND licensing rate. So they end up being economically worse off. And so, you know, the proposal of this bill, and there's also another bill in the United States Senate that would also repeal aspects of eBay. These are very good developments, and hopefully these bills will move. There isn't any indication that they will, especially in an election year right now in the United States. But you know, it's a start of a process. You know, because if you had even said to me 5 or 6 years ago that there would be congressional bills to repeal eBay, I would have thought you were crazy at the time. So it shows that people are starting to wake up in the United States to the real fundamental concerns about the negative impact on the innovation economy from the inability of patent owners to receive injunctions in the United States, especially standard owners of standard essential patents.
Well, I think with that we have come to the end of our discussion. I would like to thank the panelists for the very interesting insights. I really appreciate the opportunity to talk to you all. I look forward to seeing you in the future, hopefully next time in person. And thank you all for joining us.
Thank you so much.
Thank you.